In the case of the people of the state of Michigan versus Cyrus Body, what started as a seemingly technical legal motion quickly spiraled into an emotionally charged confrontation. Prosecutor Marie Stanley accused defense counsel, Mr. Dose, of egregious personal attacks, implying they were rooted in gender bias. The judge, clearly frustrated, found himself caught between two warring attorneys while trying to settle a critical evidentiary dispute: whether Michigan's rape shield statute applies at a preliminary examination. This transcript captures the moment the gloves came off.
I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
This is a powerful accusation and one that takes immense courage to voice in open court. Prosecutor Stanley is alleging a violation of ethical rules related to bias and discrimination. Michigan Rule of Professional Conduct 6.5, in conjunction with Rule 8.4d, discourages bias and discrimination in the practice of law. To directly accuse opposing counsel of treating her differently based on being female suggests a perceived pattern of conduct that goes beyond mere vigorous advocacy. It implies a systemic issue, and for a prosecutor to bring this to the court's attention, it highlights a deeply felt affront to her professional dignity and an undermining of the principle of equal treatment under the law, regardless of gender.
Ms. Stanley, you may proceed.
Your Honor, as counsel...
Here, Prosecutor Stanley is making a crucial point about the ethical obligations of attorneys. The Michigan Rules of Professional Conduct, specifically Rule 8.4c, prohibit conduct involving dishonesty, fraud, deceit, or misrepresentation. An attorney's reputation for honesty and integrity is paramount to their ability to function effectively within the legal system. When she says, "No case is worth me losing everything I've worked so hard for," she's highlighting that these personal attacks, especially public accusations of lying, threaten her professional standing and potentially her very license to practice, not just her feelings.
It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything had changed. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Dowse to myself. "Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you."
This email from defense counsel, Mr. Dawes, to Prosecutor Stanley is a critical piece of evidence demonstrating the personal nature of their conflict. It crosses a line from professional disagreement into personal antagonism. Under the Michigan Rules of Professional Conduct, specifically Rule 3.5c, a lawyer shall not engage in conduct intended to disrupt a tribunal. While this was an email, it directly contributed to the disruptive atmosphere being brought before the court. Furthermore, it could be interpreted as a violation of Rule 8.4d, which prohibits conduct prejudicial to the administration of justice. Such an email undermines the civility expected among members of the bar, which is essential for the smooth functioning of the justice system. It's not just impolite, it can be an ethical breach.
I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that, unfortunately,
Ms. Stanley, you may proceed.
Your Honor, as counsel, we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit here and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with.
A little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will.
The judge's intervention here is critical. By stating this was clearly personal and I expected better from you, the judge is essentially ruling on the nature of Mr. Doss's conduct. Judges have inherent authority to manage their courtrooms and ensure proper decorum. This is reinforced by Michigan Court Rule 6.001, which emphasizes the orderly and efficient administration of justice. When a judge, particularly one with over a quarter century of experience, makes such a pointed remark, it carries significant weight. It indicates that the judge believes Mr. Doss's actions were not merely zealous advocacy, but crossed into unprofessional or even unethical territory, reflecting poorly on the entire legal profession.
You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another, you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. The proposition before the court is raised at the last occasion, is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
The judge is explaining the established practice and the rationale behind applying Michigan's rape shield law, codified in MCL 750.520J, at preliminary examinations. This statute is designed to protect victims of sexual assault by generally prohibiting the admission of evidence concerning the victim's past sexual conduct. The judge's analogy of once the cow has left the bar of the field, it's out powerfully illustrates the irreversible harm that can occur if sensitive, irrelevant information about a victim's sexual history is introduced at an early stage. The judge is emphasizing that the purpose of the rape shield, to prevent undue harassment and preserve the victim's dignity, would be nullified if it didn't apply to preliminary exams, as that information would then be publicly known, regardless of its admissibility at trial.
Okay, Mr. Dawes, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the barn, the field, it's out. It's just there. Misinforming Judge Barr that the rape shield applied at preliminary examination.
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination. So, Mr. Dawes, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Ms. Town?
At this point,
All right, this court is ready to rule so that there's an order that Fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off. And that is the ruling.
So, what happened next in the case of the people of the state of Michigan versus Cyrus Body? While the specific ultimate verdict or sentencing for Cyrus Body is not publicly available through readily accessible records, the immediate and most critical outcome of this intense hearing was the judge's firm ruling on the rape shield statute. The judge unequivocally affirmed that Michigan's rape shield law, MCL 750.520J, applies with full force and effect at preliminary examinations, preventing defense counsel from eliciting irrelevant or prejudicial evidence about a complainant's past sexual conduct at this early stage. This ruling was a significant win for victim protection and solidified what the judge referred to as long-standing practice. The transcript ends here, but it leaves us with a powerful reminder that justice isn't just about applying the law. It's about upholding professional standards, ensuring civility, and safeguarding the dignity of all parties involved in the legal process.